Okay, everybody, I'm going to go ahead and get started. I didn't have any students come, but tonight what I'm going to talk to you about is the judicial branch of government. So our essential question for this topic is, why is the Supreme Court an important part of our democratic system of government? Why is it important? Some would say it's the most important part of our democratic government. What I'm going to go over today is the jurisdiction of the different courts. We're going to analyze some Supreme Court cases, compare and contrast the differences between district court and appellate court, evaluate the different ways someone is chosen as a federal judge. That's a messed up sentence right there. I'm going to list the 9 Supreme Court justices and describe the characteristics of a Supreme Court justice. So let's talk about the powers of the federal courts. Alexander Hamilton said, "Laws are a dead letter without courts to expound and define their true meaning and operation." And so what he means by this is that laws are just letters written on a paper. They're just words. But it's the courts that interpret the laws, apply the laws. And without courts, then that's all a law is, just something written down on a piece of paper. So some would say that the judicial system of the United States is an adversarial system. It provides an arena for two parties to come and bring conflict and debate, argue cases. Every case is a dispute between a plaintiff, someone who is presenting the charges, and a defendant, the person or entity that the charges are being brought against. These people are known as litigants. And they are the people who are engaged in the lawsuit. So there are two basic types of cases. You have criminal law, where an individual is charged with violating a specific law and provides punishment for that law, such as a felony is a penalty of over 1 year in jail. Misdemeanors are usually less than 1 year jail time. 98% of these cases are heard at the state and local level. And then you have civil law. The civil law does not involve a charge of criminality. Instead, these are disputes between two parties. And it defines kind of the relationship between those. And it could be, a tenant and a landlord. Okay, a mechanic and someone getting their car repaired. Okay, these would be brought up in civil law. Some of the other examples are divorce, custody, properties, and contracts. So John Marshall. And so the Supreme Court, it's important to understand that the Supreme Court played a minor role in the 3 branches of our government until John Marshall came on the scene. John Marshall is credited with increasing the power of the Supreme Court. We'll talk about how he did that in just a moment. So here are the United States federal courts. And up here at the top, you can see we have the Supreme Court. And then you have your appellate courts. That's where appeals are heard. You have your trial courts, the U.S. district courts, courts of international trade, courts of federal claims, and then other federal courts that can be trial and or appellate. Military courts would fall under this. Courts of veteran appeals, tax court, all fall under other courts, other federal courts. So Article 3, Section 1 of the Constitution says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So here are the jurisdictions, of course, and this is think of a jurisdiction as a right to ownership, a right to govern, if you will. So the federal court system consists of the Supreme Court and lower federal courts, which are established by Congress. Each court has jurisdiction or authority to hear certain types of cases. So the jurisdiction, the definition, is the authority or subject area of a court that can hear about a case. For example, if you break a federal law, then you're going to go to federal court. If you break a traffic law, like running a stop sign, something like that, then you're just going to go to a local court, or sometimes it's called a recorder's court. Which the recorder's courts or the local courts are also state courts. So here are some of the powers of the federal court system. So your federal court cases, like I said before, refer to federal law. They also enter into treaties with foreign nations. They handle bankruptcies, admiralty or maritime law, that's laws that are broken on water, on the sea. Laws against foreign diplomats or foreign governments. When two or more states have a case between them, that's going to go to federal court. Any courts that come against, or any cases that come against the United States government, will be heard in federal court. Citizens of different states, if you sue somebody in California, that's going to be in federal court. If you are going to sue the state of California and the citizen in California, that's going to be in federal court. Land grant claims of different states. The Supreme Court, their responsibilities include interpreting the Constitution, determining the constitutionality of state laws, upholding regulatory laws, protecting civil liberties, and influencing public policy. So there are different types of jurisdiction. There's exclusive jurisdiction, cases that can only be heard in federal courts. There are federal crimes, for example, cases involving ambassadors, bank robbery, kidnapping, presidential assassination, the killing of a police officer. All of that is a federal crime. Also violations of patents, copyrights, cases involving ambassadors. We always said that. The different types of jurisdiction continues with concurrent. These cases can be tried in either federal or state court. Diverse citizenship dispute involving citizens of different states is a type of concurrent. If it's more than $75,000, then that will be heard in the concurrent court. With the concurrent cases, it usually involves defendants of a different state. And so if the plaintiff wants, the trial can be moved to the plaintiff's state in this type of case. Land disputes between people from different states are heard in a concurrent jurisdiction. And then there is original jurisdiction. It's the court with the authority to be the first to hear a case. This is usually found within district courts and our trial courts where original jurisdiction takes place. Trials are held and juries may be paneled. Then you have appellate, and this is the final review of the decisions of district courts. Court of Appeals for lower court cases that have been lost are also appellate. This is where a case can be heard to the second, third, or fourth time on appeals from lower courts. Jurisdiction of the federal courts, the U.S. Supreme Court has original and appellate. So a case can be heard for the first time at the Supreme Court, or it can be appealed up to the Supreme Court. The U.S. Court of Appeals is an appellate court. They don't have any cases that are heard at the U.S. Appeals Court for the first time. And then your U.S. district courts have original jurisdictions. This is where your case will go first. So if you have a case in U.S. district court and it needs to be appealed, then it will move from district court to the appeals court. But cases in the Supreme Court can be heard the first time because it has original jurisdiction, and it can be appealed up through. So here's a little graphic showing the different hierarchy of your U.S. district courts, which are 94. They have grand juries and petite juries. Your petite jury is going to be a jury that determines guilt or innocence. It's an original court in most cases. Your U.S. Appeals, Court of Appeals, there are 12 of those, 3-judge panel, and they only hear appeals. And then you have the U.S. Supreme Court. It's original and appellate. Here's the fewest cases in a year. Anywhere from 80 to 150. That's not many cases at all. And they get to choose which cases they hear. Okay. Moving right along, some important Supreme Court cases. The first one, sorry about that. I hope that doesn't happen throughout the rest. Okay, so the Marbury versus Madison. This case created the concept of judicial review. And judicial review is a component of the Supreme Court. It gives the Supreme Court its most valuable power. And like I said before, the Supreme Court, prior to this court case right here, was an inferior entity of the 3 branches. But with the idea of judicial review, the Supreme Court gets to decide which laws are constitutional and which laws are not. I apologize for the sounds there. Chief Justice John Marshall was in charge at this time. So this gives the Supreme Court its greatest power. In fact, this is the checks and balances that are afforded to the Supreme Court. So if you can imagine that the president, say, comes up with a law, let's just say that we can't wear red shirts on Tuesday, because that's what the president does. They kind of come up with the idea sometimes of the law, and then it goes through Congress. Or maybe a regular citizen comes up with the idea and the law goes through Congress, right? And we've already learned about Congress and how long it takes for a bill to get through the lawmaking process. So here you are. You can't wear red shirts on Tuesday. That's the law. So then it goes to the president. The president either signs the law or vetoes the law. Well, let's just say he signs it, okay? Because these are our checks and balances. then it's kind of ridiculous. Some people will say, well, there's no reason why we can't wear red shirts on Tuesday. So somebody um, creates a court case that's heard for their first time with the Supreme Court, and the Supreme Court can decide whether the law of no red shirts on Tuesday is constitutional or not. And so obviously that's unconstitutional, right? Because you could wear whatever color shirt you want to on Tuesday, right? So prior to 1803, the Supreme Court didn't do this. They didn't really make these kinds of determinations as to whether a law was constitutional or unconstitutional. Another famous case is Fletcher versus Peck. This continued to extend the power of the Supreme Court to review state laws. A law was passed in the Georgia legislature. It was a violation of the Constitution's protection of contracts. Again, Justice John Marshall was the one hearing and overseeing this case. McCulloch versus Maryland, 1819. So McCulloch was the head of the Baltimore branch of the Second Bank of the United States, and he said, I'm not going to pay taxes. The state of Maryland is not going to pay their taxes because the Constitution didn't say a state has to pay taxes. Where does it say that? And so this case went to the Supreme Court, and the Supreme Court said, well, there's a necessary and proper clause in the Constitution that allows the federal government to pass laws that are not expressly provided for the Constitution's list of express powers. And so this leads to the expansion of the federal government. The Supreme Court said that the federal government can pass a law and states have to abide by that law, like paying taxes, even though it's not expressly said in the Constitution that the states have to do that. McCulloch versus Maryland. Chief John Marshall again. Gibbons versus Ogden, 1824. This expanded the meaning of interstate commerce. Understand that our country is very new at this time, and so commerce between states, and commerce is the buying and selling of goods, trade, stuff. Okay, now we do commerce at Walmart, but back then we didn't. So this this case expanded the meaning of this interstate commerce and even further extended the federal authority at the expense of the states. Chief John Marshall again. This is a very famous court case, Dred Scott versus Sanford, 1857. This court case set into law the idea of being separate but equal. Excuse me. Dred Scott was a slave. His owner took him to a free state. While he was in that free state, his owner died. And so after his owner died, he said, okay, well, I'm free. I'm in a free state. And the family of the owner said, no, you're still a slave. And so this court case right here set the tone for in a lot of ways, it's one of the causes of the Civil War, because it divided the nation into free states and slave states. Also, it reinforced the fact that slaves were property, and even though Dred Scott's owner had died and he was in a free state, he was not free to make his own choices because he was still a slave. That's what this law said. This Dred Scott versus Sanford led to other laws, such as the Emancipation Proclamation, 1864, the Outlaw of Slavery, it's written there, and the amendment, the rights of citizens and equal protection. Oh, my picture left. Sorry. All right. So, with laws, every person gets what's known as due process. This says that you're not deprived of any life, liberty, or property without due process of the law, proper constitutional procedures during a lawsuit. You may not believe it, but you really can't just be walking down the street and the police open up their car door and shove you in the back seat and you sit in jail for 3 or 4 months without somebody telling you who you are, why they got you and what you're charged with. That's due process. Oh, Plessy versus Ferguson. All right, I'm sorry, I made a mistake on the Dred Scott. This is the law that established the separate but equal doctrine, making public segregation of blacks and whites legal. So Plessy versus Ferguson was a court case that came about. Plessy was on a train car, and he was asked to go to another car, and it's sort of like Rosa Parks, actually. And he said that he did not get an equal seat on the train car reserved for blacks, and the court case was about the fact that you could still be on the train, but they were going to put you in a segregated car. So this put into place that this printed out the set forth the separate but equal, where facilities are the same. It's just that you have one race of people in one part and another race in another part. That continued, and that really is what ushered in the Jim Crow era. Legalized separation of schools, public buildings, hotels, etc. I hated that my images aren't coming through. That's really bad. Brown versus Board of Education went against the separate but equal doctrine of Plessy versus Ferguson. This is where a young girl in Topeka, Kansas, there was a school right next to where she lived, yet because she was black, she had to walk a number of miles in the opposite direction because she couldn't go to the school that was closest to her. This case, her name was Linda Brown, and so her father brought the case to the Board of Education of Topeka, Kansas. Thurgood Marshall argued the case and won. That got rid of separate but equal. That was in 1954. Thurgood Marshall ended up going on to being the first African American Supreme Court justice. Miranda versus Arizona. I hate that my pictures aren't coming through. This falls in line with due process. This is where the police have to inform you of your constitutional rights at the time of the arrest. The constitutional rights include you have the right to remain silent. Anything you say can and will be used against you in the court of law. And I don't know the rest, thankfully, because I've never been given my rights. This was under Chief Justice Earl Warren in a 5-4. Okay. Roe v. Wade. This is a famous court case in the 70s that legalized abortion. And it's a huge law that has impact today. So lower federal courts. Courts that are established by Congress under Article 3 are constitutional courts. Federal district courts, these are created by Congress and serve as trial, not trail. That's bad. We have, like I said before, we have 94 district courts, 646 judges, 2 judges per district. Usually they preside alone. They handle a lot of cases. These are the types of cases that they handle. The Federal Court of Appeals, established in 1891, is a 3-judge panel. Currently there are 13 courts, 12 judicial circuits or regions, 1 for the national jurisdiction. DC and Federal Circuit make up 13. I think this is the picture showing the different districts. I hate that it didn't come through. Federal claims, you suing the federal government. These are some special courts, territorial courts, courts of District Columbia, U.S. Tax Court, Court of Appeals for the Armed Forces, Veterans, International Trade. So Article 2, Section 2, Clause 2, Supreme Court appointment process says that the President shall nominate and, with the advice and consent of the Senate, shall appoint judges of the Supreme Court. Yeah, that's why it's always such a big deal when a president is able to appoint a judge, a Supreme Court judge, because normally it's with party affiliation. In other words, if President Trump appoints a Supreme Court judge or nominates a Supreme Court judge, then most likely he's going to be conservative because that's what Trump is. Same thing with the Democrats. If they nominate a Supreme Court judge, then that person is usually going to be liberal because that's what they are. They even have the same kind of judicial philosophy and courtesy. Usually have a background of legal training. They've been state court judges in the past. So, SCOTUS, you see that? SCOTUS, as it's called. Supreme Court of the United States. When it's the president, then it's the POTUS. I hate that my pictures are not coming through. Okay, so it's the ultimate court of appeals, the Supreme Court. If you don't get your answer in the Supreme Court, then that's it. There's no more courts for you to go to. It's usually determined by the rule of law or process. It's not the merit of the case. They are the final authority. They are not required to hear all cases. They hear the cases that they want to hear. If they choose not to hear a case, they have to give a rationale as to why they have chosen not to hear it. And this is what the picture was. Until 1891, a lot of the Supreme Court justices rode around on a horse and visited their circuits, their different areas. As I said before, the Supreme Court has both original and appellate jurisdiction. Article 3, Section 2 sets the court's original jurisdiction and covers 2 types of cases: the representation of foreign government and the state as a party. The Supreme Court's in session the first Monday of October each year and usually continues through June. Receives and disposes of approximately anywhere from 5,000 to 9,000 cases a year. The subject matter does not matter. And cases are heard with all justices sitting together in an open court. There's 9 of them. This position is for life. Until they resign, retire, or die, they are the Supreme Court justice. They can be removed through impeachment. The salary is set by Congress and it cannot be decreased during their term of office. The Supreme Court justice's salary is the same as U.S. senators and representatives and vice president. The main duty is to hear cases, decide what case to hear. They will also give explanations for their decisions. These are called the court's opinions. It's located in the back of the Capitol building. There are 9 justices, 8 associate justices led by a Chief Justice of the Supreme Court. John Roberts is the Chief Justice. This is his information. And I hate my pictures didn't come through because I think they would have really... So the appointments of the Supreme Court are influenced by the political ideology and partisanship of the president, the interest groups, and other justices and senators. All lawyers get their certification through the American Bar Association. Okay. All right, that's a lot. So that is our judicial system. I hope you've enjoyed talking or hearing about this. If you have any questions, please feel free to reach out to me. I'll be happy to help. If not, thank you for listening and have a great day.